Welcome. Today we will have a discussion on a fairly, I would say, controversial topic at the moment, which is the sentencing of British or English dissidents and how the court has started to divvy out very harsh sentences for certain subjects of the Crown who have been running amok. Now, the way we can take a look at this will be a little bit more around the legal jurisprudence, but then also the structures of the laws in place in England at the moment and what that means from a sentencing point of view and juridical and judgment or justice point of view, and how we can think about that. It might be a little bit longer video, but I can assure you it's fairly important if you want to understand why it seems like there's some very harsh sentencing going on in the UK at the moment, and then we can give a bit of context as to why that is the case, both from historical but more recent, since the 1986 Public Disorder Act. So I think it's best if we start maybe with an understanding of English law to begin with. Blackstone, William Blackstone was a jurisprudence or a legal scholar in England in the 17th century and wrote a huge volume of work on the laws and the legal guidelines of England. And the idea was for him to provide a more comprehensive understanding of why certain laws are the way that they are and what you can actually think about in terms of justice and the nature of law itself. So very, very much pure jurisprudence. He wrote, it was called The Commentaries of Laws in England. The book we want to read today is his fourth volume of the set of five, I think, where he goes through kind of public punishments and sentencing and things like that. So we'll have a look at what he says, but then also how we can understand it from a modern perspective as to why is the English system so bonkers to people who aren't familiar with it. When you think about English law, you have to remember that it's based on old Germanic Teutonic law. So the Anglo-Saxons, but also the Danelaw and the Vikings, all had a very similar understanding of law and legal precedents. It comes down to, as all law, property, and Carl Schmitt outlines this in The Nomos of the Earth, but that property law and the basis of almost all law is around property, and that's either private personal property, including your body, or it's public properties and the king's, you might call it the king's properties. And here we can understand that a person is a private individual, but also a subject to the Crown, and thus there's a dual level of legal liability. So if I go out and harm someone in public, I can potentially be doing a disservice to that person, but then also to the Crown, as the subject is now impacted and has their rights infringed from that angle. The little picture here I've got is just an illustration of what was called wergild, but there's a valuation mechanism to harm that you were expected to pay an equivalency, either in your own life or a reflective punishment which was commensurate to your own crime. So if you injured or harmed someone, then potentially you were going to be injured or harmed yourself or exiled. But if you murdered someone, then it was possible to pay. Now this is where the English law makes more sense, is if you understand that in wergild, certain people are more important than others. So the cost of that person's, the commensurate cost of that person's disability or their injury or death could be higher, which is how we get this class aspect of someone in a certain class is worth more than people in lower classes. And this distinction between, say, a king and a thane and then a thrall and a herdman and a slave, and you have these layers of worth, then you can understand that the English system is very similar, with the underclass being not worth that much. And in the eyes of particularly Parliament and people like Starmer, but also the political body in general that participates in both, like I say, legislation in Parliament, but then also the courts and the magistrates, have a notion that they are above the lower class, and therefore the dictates that they serve are separate and worth different amounts to the lower classes. In modern America, this is probably an affrontage where in a lot of court cases, people are surprised that you can buy a really expensive lawyer and get different treatment in an outcome. where it's less surprising for people in England because they've lived with it for 1,000 years now, where if you were poor, your punishment was always much harsher, almost no matter what, and your ability to hire legal representation is always either non-existent or just of worse quality due to the economic factors around that. The idea that we have a country which was used to dealing with its underclasses in a very assumed criminal manner can be seen at, I just took an excerpt here, but that between 1788 and 1868, the British penal system transported about 162,000 convicts from Great Britain and Ireland to Australia. So the idea that the treatment of criminals as underclass, and that there was a will to get rid of them and sweep them under rugs and deport them, has been a very constant theme throughout the English history, and that there has been several waves of migration away and out of England due to the dissatisfaction either of the communities or of the, you could call it the legislation and the government body around a certain type of underclass that they wanted to get rid of. Particularly around the usage of the army. So a lot of the time when conscription and certain mass armies were popular in the 17th, 18th, 19th centuries, you were able to get rid of a lot of your lower working class people by putting them on boats, shanghaiing them onto a vessel, or you could obviously have them serve in the army and just push that army into India or into Africa somewhere and not have to think about having a lot of surface of low labour class men. So in particular, the English system is designed around this imbalance, and you would rightly call it a discrepancy of your worth and also the value you represent to the legal system. Current sentencing has been along the lines of, with English law, a interpretive system. So you don't have a constitutional law like you do in some countries where there's a very strict did you or did you not break the law as per the guideline. In English law, it's still an interpretation on legislation, so there's a lot of leeway, you might call it, and when it comes to case law, you have precedents on certain guilty, not guilty, and then sentencing guidelines, things like that. So there's a lot more free form. So the law in England kind of grows alongside society in a way. You could call it very Germanic, and Spengler has, in the sense that it reflects what would be the Faustian law. Now, the just part of this is always a perspective. It's always a subjective and qualitative part of your existence, but your social contract, you might call it, if you're a fan of John Locke or Rousseau, whereby you've engaged with society and therefore you must abide by social expectations. England is really focused on having civility, and this primarily affects the lower classes, because the lower classes historically have been the only ones who have sought to do certain things in certain ways. So this is just to give you some context here, and as I said, it's going to be a fairly longer video where we can dive into what it means. But it's important to understand that there's not necessarily a judge of your peers. You do have peer review and court-appointed juries for certain topics, but if you've pled guilty, as is the case with most of these convictions in the current riots and the racial hatred acts and things like that, then there's the circumvention of needing a jury. You just don't have to go into court and labour around the case and have your lawyer present anything, because you've proved, you've pledged, or you yourself have admitted guilt. Now, the reason you would do this is because if you're entering a guilty plea, and you can see here actually I've taken an excerpt from the UK criminal justice website, that the reduction of 1/3 should be made. So the reason that you see all these people being fast-tracked is because they are basically arrested and then remanded, and then once that occurs, they're threatened quite heavily with the hard hand of the law. Some of these sentencing guidelines have punishments up to 10 years, so you can go to jail for 10 years for being part of a riot, which is a very loose and ephemeral term for a gathering of more than 12 people which has some concerted effort towards something. So having the ability to go to jail for 10 years obviously is fairly confronting and scary for some people, which means that they'll happily reduce whatever sentencing they get in the hope that the judge is going to be lenient towards their sentencing. And as you can see, there's a drop off. So if it's after the first stage of proceedings, it's only a quarter, down to a maximum 1/10 on trial. So the incentive is for the courts to minimize the amount of trials. They don't want you being represented by a lawyer, taking a lot of time, presenting evidence, going through the rigmarole of a courtly procedure to then offer a sentencing, because they're using what is a stick to threaten you, more or less, with harsher sentencing if you do that and are still found guilty. This is fairly common. It's commonplace in most Anglosphere countries in the way that the legal precedents work. Which is to say, do we have a two-tier court system? Of course, and I'm demonstrating here that there's been a two-tier, or more than two-tier court system since time immemorial in the UK. We're just more aware of it now, perhaps, or we're more conflicted in how we feel about the causes and the responses to certain people who are now suffering from this two-tiered, multi-tiered, poly-tiered system. The idea that there can be large groups of men wielding weapons, as you can see here, it's typical that you have a maximum 3-year sentence for an affray. An affray is this, the wielding of a weapon of a type of manner likely to cause people substantial fear for their safety. We saw video evidence of a lot of men of a certain background doing that, and then very few charges of affray, right? So it is the case that there's this political will for a certain segment of the community to be punished more evidently and more, you could say, with media hysteria around, versus another part of the community where we acknowledge that it's an issue, but we don't want it to be publicized for fear of something related to morality and ethics, perhaps. But then it comes down to the judges and the magistrates, and this is where the crux of the UK legal system resides, in that a judge has discretion, and you have to understand discretion as being a man or a woman operating within guidelines, and particularly around sentencing. But at the end of the day, how they feel in terms of the sentencing is going to more or less determine your outcome from, will I serve a 2-month sentence or a 50-month sentence? As long as it's within a maximum minimum, the judge's discretion and how they're feeling on the day might vary, and if they like you or don't like you personally can impact your sentencing. No one will admit this, but there's no oversight committee with enough power to actually enforce any reflection on this. There's juridical review committees and things like that, but they're just fairly impotent when it comes to whether or not a judge or a magistrate has been just and is using the fairness principles that they have signed up for. And this, I think, is why we can see with Blackstone here that he's able to identify what is modern problems using a justice system which is biased and is concerned mostly with punishment as a dissuasion. So here he goes on to say that we may observe the punishments of unreasonable severity, especially when indiscriminately inflicted, have less effect in preventing crimes and amending the manners of people than such as are more merciful in general, yet properly intermixed with due distinctions of severity. And just outlining that the harshness of a crime is not always reflected in its sentencing, because you potentially want to dissuade future occurrences of said crimes. So if someone was graffitiing and prolifically, and you said, I don't want this to be a repeat occurrence, even though the criminal damages might have been minor, I'm going to apply the harshest sentencing possible, so that the next person who thinks about doing this knows that the last person got a very hefty sentence, and then, you know, if you were to do this yourself, then you will also get a hefty sentence. So the aspect of justice for the actual individual takes a lower important level than the more broad and official punishment as seen and perceived by the public in general, which is fairly unfair from, you know, if that's me being punished collectively almost for future crimes and a dissuasion tactic. But that's the way that the law is set up in the English and the Anglosphere. And he goes on to say that when punishment surpasses all measure, the public will frequently, out of humanity, prefer impunity to it, which is where the lessons might come in for particularly the modern Labour government if they are so intent and adamant about punishment as this in this way. There's two elements to it that they need to remember. Is that one, punishment dallied out and dictated to certain groups can always be weaponized. Now, that is to say, currently the receiving end, the victims of certain crimes, are this underclass and lower class with no political power. But the precedents can be set where, and if you flip what that means in terms of hierarchy, and you suddenly have the people with the stick no longer with the stick, more or less, then it is a risk that you run that the same laws and precedences can be used against you. And this is particularly evident in countries where I mean, the UK will never have a coup like that, but at the coup d'etat, you can obviously see that a new dictator is fairly harsh towards the previous dictator or government in terms of what was received as punishment and felt by the people as injustice is now commensurately or even astronomically higher reverberated back upon them. So we have to think that you, as I say, A, run that risk, but then B, a complete and utter failure to, as it says here, impunity, but have the polity respect and abide by laws, because the nature of law is such that if I know I'm going to be punished harshly anyway, then there's no dissuasion. You've basically just applied very harsh and not unenforceable, but very untenable law punishments on certain legal precedences. It's a dilution effect almost of that law to say, like, no matter what, even if you do it very mildly, you'll still be punished as harshly as someone who's very grossly and extremely violating that law. Then you may as well go and do the most extreme version, because the punishment is going to be equivalent anyhow, which is kind of the opposite of around dissuasion. But anyway, that's you could call that the risk that particularly Labour and Starmer, because of his legal background, maybe forgets is a political repercussion of a legal system that overreaches, or at least is extreme in its behaviours. And this is why Starmer is a bad Prime Minister. It's because he's too legal. He's too much in this, I'm a barrister and this is how crime and punishment works, which is unfortunate, because the political system in the UK is built in such a way that you can have this two-party system where you'll only need 20%, 30% of a body politic to vote for you to remain powerful, and the legislative capabilities of a party could be, and they are, a majority. So you can pass any legislation with a mandate of only 25-30% of the population, voting population, which is, as most understand, a very misrepresentative of the body's wishes. But in this case, I think we have to be slightly concerned that the stretching and application of law, if it is not homogeneous and even, will allow for certain civil unrest to foment than it will quell. I think the precedents being set like this can be reflected in how the average custodial sentence has actually increased from what was about 10 to 12 years, and this is to say, like, crimes haven't necessarily gotten worse. If anything, there's been a drop in crime, so the severity of crime matched to certain sentencing guidelines has changed, in that we now feel, and this is represented through Parliament's legislation, a representation of, they feel you should be punished harsher for the same crimes 20 years ago in the same nature and the same, as I said, magnitude. So the sentencing has just gotten harsher, which is to say judges and magistrates have felt that they are allowed or warranted with harsher punishments to the same crimes. I've taken an excerpt here from the English and Wales sentencing body, where they've said prosecutors, and this is in relation to charges, not necessarily sentencing, but that prosecutors should always mind the following general principles when selecting the appropriate charges. The charges should accurately reflect the extent of the accused alleged involvement and responsibility, thereby allowing the courts the discretion to sentence appropriately. The choice of charges should ensure the clear and simple presentation of the case, particularly when there is more than one accused. There should be no overloading of charges by selecting more charges than are necessary just to encourage the accused to plead guilty to a few. I think for this one, the should is very optional. Should, not ought, not will, not could, but very much a, this should be the case, and if it's not, well, who's to say anyway? And this is the problem with the UK legal system. There isn't anyone to say, except Parliament, and Parliament have obviously got their interests aligned here. There should be no overcharging by selecting a charge which is not supported by the evidence in order to encourage a plea of guilty to a lesser allegation. All of these shoulds, as you can see, are basically worthless to prosecutors at the moment, because the Crown will seek to prosecute you in a way that they know they can get a conviction as fast as possible. There can be no acceleration of a legal system in any meaningful way that is still able to handle what you would call a justice, but the due process of the law. I mean, discovery and all of these elements are fairly much whitewashed or completely gotten rid of because of the way that the accelerated remanding and sentencing, charging and sentencing has been done by the Starmer government. Which is lastly, I think, to kind of highlight here around the CPS, which helps prosecute certain hate crimes. And this is where the last and very important part of the English issues, or the current unrest, and then why it's such an important integral issue, is because the language used in the 1986 Public Disorder Act, not just around rioting and public affray and disorder, which is the part 1, but part 3, which is around the hatred speech. And this is where you'll see a lot of media attention on specifically hate crimes, but then a call to incitement of violence towards certain groups with prejudice against them, bigotry, etc. This is because the law is written in such a way that it's interpretive, and more interpretive than I would say that is maybe normal. So it's very difficult to be very certain you're not offending anybody, because as you can read here, a person who uses threatening, abusive, or insulting words or behavior, or displays any written material which is threatening, abusive, or insulting, is guilty of an offence if he intends thereby to stir up racial hatred, or, having regard to all circumstances, racial hatred is likely to be stirred up thereby. But as you can read on the CPS website, they've said any criminal offence which is perceived by the victim or any other person to be motivated by hostility or prejudice. That sentence alone should determine whether or not you feel as if you're living in a state which can either impugn you or indict you, but then necessarily remand and charge you on your thoughts and the way that you've communicated them. And it's to say, I can feel like anyone is being racist to me for any reason if I just identify myself with a group which could be oppressed by language determined by the court, which is just basically a prosecutor and a judge agreeing to say, yeah, that actually, you know what, that seems very hostile. That seems like that person's very much oppressed by language used by another party that's bigoted and prejudiced. That's it. That's the thin veneer of whether or not you're a criminal is now down to a perception of a victim against another person on the language or the type of communication that they've used. And we can say, oh yeah, you're inciting through very obvious means. If we're calling for a raise in arms, or you're calling to go out and do things, that's a very obvious incitement, and you'll get convicted for that, and probably justly. But the idea that you can have a criminal offence down to perception of a victim is frightening. I mean, it's truly, and if you are middle class, you'll probably never have to really feel this as a legitimate political threat, or at least a legal threat. But if you are in a class which is not that protected by law, as we can see in England, it's not very much the case that being poor is fair treatment. This is not Germany or Sweden. Then you will be liable, at some point in time, for some comment you may have made on Facebook, to be charged with what could be considered a 3 to 5 to 10 year sentencing, depending on how harsh and strict the legal process is towards punishing you. And as I said before, in sentencing, the precedents can be set that you are to be the whipping boy, shown as a pariah to the world, that don't do this, don't wrong think, don't use this type of language against this group. And that's it. That's the really the opinion, but like the thin fulcrum between whether you're guilty or not as a criminal, and like as a for life criminal who's been in jail and can now no longer work certain jobs and have certain opportunities to them. That's it. That's the language. So this is kind of, I guess, why the impetus for the video is to say that if you are considering engaging publicly in any of this discourse, you have to be very, very careful. It's not the case that you can, and this is where this law becomes even much more of a joke, but it's not the case you can write whatever you want, except if it's for a program. So if you can technically show that you're repeating or communicating in a way that's for programming, you're actually exempt from the law, which is some very clever 25-year-old solicitor's way of saying the BBC and ITV and all these media publications are free to publish whatever headlines they want because it's for a program. It can be on TV. Then the normal person who's trying to communicate to whoever they may be in touch with in ways that they feel is warranted and justified. So necessarily you can see here that there's been a huge charge rate, conviction rate and sentencing. And as you see, there's a lot of racial cases here that the CPS is bragging about. So congratulations to the CPS on their very hard work. I'm sure they've kept a lot of criminals off the streets. And I'm sure if we go and look at the incidences of rape and violence and all these very minor crimes compared to these crimes, we're going to see such an improvement in social trust and societal uplift, huh? Yeah.